Hi, I'm attorney Kelly Longtin from Kelly Longtin Law, and today we're going to talk about beneficiary designations and estate planning. So now you regularly check your balances of your retirement and your bank and your investment accounts. But when was the last time that you checked the beneficiary designations on those accounts? And really any accounts that you have that allow you to name a beneficiary. Now, it may have been years since you first opened an individual retirement account or bought a life insurance policy or started putting money into a healthy savings account. At the time that you named someone, you probably most likely named your spouse if you were married or another loved one if you were single. When you set it up, you may have listed them as beneficiaries so they would inherit your money when you passed away. However, you might have since divorced, you may have gotten remarried, you may have gotten married altogether and never looked back to see who those beneficiaries were. Perhaps you had a new child or a loved one, or perhaps somebody really close to you has passed away, and maybe that has altered your estate planning strategy overall. Beneficiary designations are a crucial part of an estate plan and a way to avoid probate, but they supersede instructions in a will or a trust and should be regularly reviewed to ensure that they will align with your legacy goals. So let's talk about different types of accounts that have beneficiary designations. Beneficiary designations allow individuals to specify who will receive the funds or accounts when they pass away, bypassing probate and allowing these items to pass more quickly to the people or entities that they've named as beneficiaries. Many types of accounts and financial instruments, such as the following, allow for beneficiary designations. And this includes payable on death or transfer on death account designations as well. So retirement plans such as 401k, 403b, individual retirement accounts known as IRAs, Roth IRAs, or pension plans. You can also put beneficiaries on life insurance policies and annuities, on checking and savings accounts. You can put them on CDs, healthy savings accounts, even on 529 plans and any employer-sponsored benefits, such as group life insurance or employee stock plans. You can always set it up so your brokerage account has a beneficiary, your mutual funds, and even those U.S. savings bonds. Now, some states also allow real estate to pass to a beneficiary using a transfer on death deed, a beneficiary deed, or a ladybird deed, also known as an enhanced life estate deed. Let's talk about how a beneficiary designation works. Beneficiary designations take precedence for distribution over other documents in an estate plan. The individual entity that you name as an account beneficiary will automatically receive the money or the account, usually without it passing through the court-supervised probate process. A beneficiary can be any of the following: person such as a spouse or child, partner, family member, or a friend. It can be a trust, it could be a charity, it could also just be your estate. It is also possible to name multiple parties as beneficiaries of the same account, allowing you to divide the money or account among them. For example, if you could have half of the money in your investment account pass to your spouse, and you could split the other half between your two children. Now, federal law, your state, or the account administrator may require that your spouse be listed as a primary beneficiary and receive a minimum amount before you can list other beneficiaries, unless the spouse waives their rights. If you name your estate as a beneficiary, the money or the account could be subject to probate. However, the money or account may still require court supervision in some instances. For example, if you've named a minor or an incapacitated individual as your beneficiary. Let's talk about naming primary and contingent beneficiaries. In addition to naming a primary beneficiary, the person first in line to inherit the money or the account, most policies that you name at least one contingent, backup, or secondary beneficiary. A secondary beneficiary receives the money or the account if the primary beneficiary is unable or unwilling to accept it. For example, if they predeceased the account holder or if they die at the same time. While primary and contingent beneficiaries provide some probate avoidance security. If there is no primary beneficiary to receive the money or account and no listed contingent beneficiary, then that money or account could be subject to probate and distributed according to applicable state law. With your estate planning attorney's guidance, consider naming your trust, if your estate plan includes one, as primary or contingent beneficiary to help avoid the scenario where both your primary and contingent beneficiaries predecease you or are otherwise unable to take the funds. Also, I want to discuss why you need to review beneficiary designations regularly. A beneficiary designation supersedes any instructions in a will or trust about how to distribute money in an account or policy. If your will states that your money and property should go to one person, but your retirement account designates someone else as a beneficiary, the beneficiary designation on the account takes precedence. Many people make the mistake of assuming the opposite, that their will or trust overrides beneficiary designation forms. It is also problematic when an account owner submits a beneficiary form to a plan custodian or administrator, but never confirms that the designation was processed. There could even be instances where the beneficiary form was left blank, either accidentally or with the intent to fill it out later. A beneficiary form that is not up to date can result in assets getting tied up in probate or not passing to the correct beneficiaries. Not updating a beneficiary form could have unintended consequences, such as leaving money or the account to a loved one who is now incapable of handling them, or to someone you no longer want receiving the funds. An estate plan should be regularly updated to account for life changes. This includes examining beneficiary forms when the following types of major life events occur. If there's a divorce, if there's a marriage, a birth or an adoption of a child or a grandchild, perhaps the loss of a spouse, a child, or other beneficiary, the end of a relationship, the closure of an account and moving the assets to a new account, a plan administrator being brought by or merging with another financial institution, an employer changing plan administrators for the benefits it provides, changes in law that affect how money and accounts can be transferred at death. While the events listed that I just went over with you can warrant an immediate change in beneficiary designations, it is prudent to check designations every 3 to 5 years, even when you think nothing has changed. Changing your mind about your overall estate plan is another time to consider switching beneficiaries. For example, your original intent may have been to divide your money and property evenly amongst your children, but you have since decided that one child needs more money than their siblings. You may need to update your retirement account to make that child the sole account beneficiary. So how do you change a beneficiary designation? Updating beneficiaries is straightforward, but the actual process can depend on the type of account. Many accounts can be checked and changed online. Some accounts require filling out paperwork. In certain states, a spouse's written consent may be required to name someone else as a primary beneficiary. A beneficiary change could require a sign-off from a plan administrator. Now, when naming a beneficiary, be as detailed as possible. Most designation forms ask for a person's full legal name and their relationship to you. You may also need to provide details such as beneficiary's contact information, date of birth, and social security number. Part of the change process should also include requesting and saving beneficiary change confirmations from the account administrator. This is the only way to ensure that the change was successfully made. So what can happen when you don't update beneficiary designations? If you fail to name a beneficiary or do not name a contingent beneficiary, in case something happens to that primary one, the money in the account could be subject to probate upon your death. The probate process can add costs and delays to settling an estate. Probated accounts and property must be reviewed by the court and distributed in accordance with the will instead of a beneficiary designation. If you do not have an existing will, the money or account would be subject to state intestacy laws, which determine who has the right to receive your money and your property when you pass away. These laws typically give preference to a person's spouse and children. but you may want somebody else to receive your money or your accounts after you've passed. Beneficiary designations show how even small estate planning details can have a big impact. While the form to name a beneficiary on an account is typically easy to fill out, naming or failing to change a beneficiary can have a major effect on your estate plan and your loved ones. A beneficiary designation cannot be changed after you are gone. To ensure that your account money and property go where you want and how you want, talk to a qualified estate planning attorney and put your plan in place. I want to thank you for watching. I'm attorney Kelly Longtin. Please like and subscribe our page below to learn more about estate planning, the options you have, and how it can benefit you and your loved ones.